So we're talking about Andrea Yates. The question was, was she competent enough to stand trial? The first time they decided she was, then they retried her, and they decided that she wasn't. Did you walk the stairs?
Yeah. Happy Halloween.
Happy Halloween to you. Today is the first day of the Day of the Dead. Day of the Dead. Tomorrow is All Saints Day, and then the next day is All Souls Day. So it's a 3-day holiday.
Don't forget daylight savings.
That's Sunday. I don't think that's All Souls Day. Okay, so we have Andrea Yates, and they determined that she wasn't competent enough to stand trial, and eventually they sent her to my college. No, actually they sent her to the prison that is in the same town as where I used to teach. Competence to stand trial refers to defendant's capacity to function meaningfully and knowingly in a legal proceeding. Defendants may be determined by a judge to be competent if they are seriously deficient in one or more abilities, understanding the legal proceedings, of course, communicating with their attorneys, appreciating their role in the proceedings, and making legally relevant decisions. We just had the guy that shot up the school, the theater in Aurora, was determined to be insane. Loeffner, the guy that shot Gabby Giffords down in Tucson, was considered incompetent to stand trial. The accepted national standard for competence to stand trial is a sufficient present ability to consult with one's attorney with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against one. And this was determined in 1960 in a case called Dusky versus the United States. This is Dusky. And it was determined that Dusky was not competent to stand trial because he wore a funny hat. No, that couldn't have been it. It must have been something else. He couldn't converse with his lawyer. The Dusky standard does not specify how the evaluator assessing competence should judge the sufficiency of rational understanding, ability to consult, or factual understanding. That's the role of the judge. The judge is the one that determines whether this individual can stand trial or not. However, a number of courts and mental health groups have listed more specific criteria related to competence to allow evaluators to provide courts with more detailed information in these areas. And here we go. According to Zapf and Roche in 2009, for example, evaluators may consider a number of relevant psychological abilities, understanding the roles of key participants within the legal process, the current charges faced by the defendant, the elements of an offense, the consequences of conviction, the rights waived in making a guilty plea. And of course, that has to do with understanding. Appreciation, the likelihood that he or she will be found guilty, the consequences for the defendant of being convicted, the defendant's appraisal of the available legal defenses and their likely outcomes. What happened yesterday? Something happened yesterday. Donald Trump claimed that he could change the 14th Amendment. 14th Amendment has to do with if you were born in the United States, then you are a citizen of the United States. That's what the 14th Amendment says. If you're born in the United States, you're a citizen of the United States, whether your parents are citizens or not. And he said that he could, by executive order, by fiat, he could rescind that, so that just because you're born in the United States doesn't mean that you are a citizen of the United States. Okay, he said he could change that. Kind of an odd time to talk about that, isn't it? What, a week before the election? Isn't that interesting? So what do you think about that? Of course, all you guys have been here for ever. Exactly. Could he do that? Should he be able to do that? Of course, you don't think that any immigrant should be able to be a citizen of the United States. You want to kick us all out, don't you? Let's think about it. How many people? No, just kidding. Don't, you'll make me cry, and I don't want to cry. Not with this. If my nose runs, I lose the yellow stuff underneath my nose. So if I start crying, you'll just see these streaks of in my makeup.
I think we'd keep you here.
I'm sorry?
I said, I think we'd keep you here.
Okay, so you want to kick us all out?
Get everyone out, keep you here.
You're gonna let me stay. I can stay. Maybe we should only be here by invitation. Maybe that's the way it ought to work. But he claims that he can do that. Of course, we've got, according to some news sources, we got that caravan heading up from South America. Why are they heading here? Where are they coming from, and where are they going? Are they coming here? The caravan? Does anybody know anything about the caravan?
Yeah.
I just make it up?
United States coming in.
Caravan? Whole caravan of people? How many?
7,000.
7,000? That's not too bad.
Yeah.
Can we absorb 7,000 people?
We took them to Columbus.
There you go. There were only a couple hundred of those guys. Well, some people don't want them to come across the border. So we'll see what happens. Keep saying it. You gotta stop saying
Was
it.
it they put like about 2,000 true reserves on the board?
5,000.
5,000 now?
5,000. Oh, look at
I
you!
like your costume too.
I like your lipstick.
Thank you.
I have lipstick. I have lipstick.
We're watching a tribe in the last tribe with their eyes. Tribe. The men.
I like your hair.
It's hard. I don't have a bald spot now. I painted it over. It's really kind of cool. Purple hair. It could have been red.
Could have been red.
Could have been red. I had red at home. I decided on purple. So we're the only fun people?
I guess so. We're only oddballs.
Wait a minute. No. It's fun people.
It's fun. This is probably
Not
the only
oddballs.
time of the year I get to wear everything that I like in my closet all at the same time.
Is that it? This is all there is? Okay.
No, there's
No,
more.
there's
I'm gonna
more.
do costume changes after, and then another one in the evening.
So next year we can, or you're going to dress up again tonight? Different clothes? Okay.
I always dress up tonight.
Yeah, right. Oh, wait.
Yeah.
Are you
come
coming to
over,
my
come
house?
over. No, you come over to my house.
I don't know where your house is.
In X-ray housing,
Okay.
in the one with the fence. You have to come in through the fence.
I have to come in through the fence. If I climb over the fence, I'll
Yeah.
get shot or
Did you
something?
make it like a little spook walk kind
Yeah.
of thing? Cool. Yeah, my kids' aunt's coming from Paige, so she's gonna take them trick or treating while I'm at home passing out candy.
I bet you're passing out
Noodles.
noodles and
Juice.
juice, yeah.
Candy and little prizes.
Okay. That sounds.
The little babies, I don't give them candy. I usually give them like a little bath toy or a little toy.
Oh,
It's
cool.
like, there you go, Mom, you don't check candy.
Oh, good. Appreciation, the likelihood that he or she will be found guilty, the consequences for the defendant of being convicted, the defendant's appraisal of the available legal defenses and their likely outcomes, the defendant's appraisal of whether or not to testify, the defendant's ability to make rational decisions regarding the specific case. And of course, that was a question with Andrea Yates. Did she have the ability to testify on her own behalf? Reasoning to distinguish more relevant from less relevant information, to seek relevant information, to weigh and evaluate various legal options and their consequences, to make comparisons, to provide reality-based justification for making particular case-specific decisions or conclusions. Assisting in one's defense. consulting with his or her lawyer, relate to the lawyer to plan legal strategy. Has anybody ever had a lawyer? Or my sister was a lawyer. She was just impossible to talk to. She was horrible. I can't imagine being, I mean, I never needed her, of course, but I can't imagine. Some lawyers are just jackasses. Is your lawyer jackass?
Yeah.
Okay. I mean, they're arrogant. Because they think they have all the right answers, and they can send you to jail if they want to, which is kind of true. To plan legal strategy, to engage in his or her defense, to challenge witnesses, to testify relevantly, to manage his or her courtroom behavior. Decision-making abilities relevant to decisions likely to arise during the proceedings. I got that quarter in my cup, it won't come out. The issue of competence also arises when defendants plead guilty. By pleading guilty, defendants waive several constitutional rights. So this is what happens when Manafort pleaded guilty. When Page pleaded guilty, one of the things that they did, they gave up these rights. They gave up the right to a jury trial. So they said that they were guilty. The only person that was going to decide anything about them was the judge. The right to confront their accusers. In this case, their accusers were the federal government. The right to call favorable witnesses. And of course, nobody was going to testify for them. The right to remain silent, of course. Now they've lost that right. So here we have Paul Manafort, who had a jury trial and lost. So then the federal government was going to try him as well, but he pled guilty. So what does that mean? That means that he has to answer all the questions that they ask him. So Mueller gets to ask him whatever he wants to ask him. So this could get interesting. We haven't heard about this whole Mueller and the anti-collusion case. We haven't heard about it for about 3 months now. And the reason we haven't heard about it is because of the election. They decided that they were going to shut the thing down until after the election. Because if they kept it going during the election cycle, then it would be detrimental to one party over the other. The Supreme Court has held that waiving such important rights must be done knowingly, intelligently, and voluntarily. So you can't just plead guilty. A lot of times the judge won't let you plead guilty. He'll say, why don't you plead not guilty? Well, it's the case of the individual that shot up the synagogue. He has already gone to court, and he has already pled not guilty. Now, the case of the individual that, the bomber, the individual that has sent all those bombs through the mail, 15 of them so far. 3 of them went to CNN, interestingly enough. But he has pled not guilty. Now the interesting thing about that is, there may be more bombs out there. But he can't tell anybody whether there are or not, because if he does, then it's the same thing as pleading guilty. Okay, so we may have more bombs out in the post office system somewhere, as exciting as all that is. The U.S. Supreme Court ruled that the standard for competence to stand trial will be used in federal courts for assessing other competence questions. Now you notice we're talking about federal courts. Normally the states will follow federal courts, but they don't have to. They can make their own laws if they want to. So the only thing that the Supreme Court can say is this is federal law, and this is in federal court. So the competence question came up in 1993 in Godinez versus Moran, thus rejecting the idea that competence to plead guilty involves a higher standard than competence to stand trial. It doesn't. And this is Godinez, who was part of that case. Why did it not go anywhere? There you go. Okay. I have no idea why I put that picture up there. As a result, the terms competence to plead guilty and competence to stand trial have become confusing. Some have suggested that adjudicative competence is clear. The question of a defendant's competence can be raised at any point in the criminal process, and it can be raised by the prosecutor, the defense attorney, or the presiding judge. So anybody can ask the question, is this guy competent to stand trial? The prosecuting attorney, the judge, or the defense attorney. Normally it's the defense attorney, and it's the presiding judge that has to make the decision. Once the question of incompetence is raised, the judge will typically order an evaluation of the defendant, and now, of course, the psychologists come in. Are you supposed to be a gypsy?
That's everything in my closet,
Okay,
but no.
including the black lipstick.
Yeah.
It's quite a closet you
No,
got.
I'm the female rage. I'm a raging female.
Okay. But you're not a Cajun, a raging Cajun.
Could be.
Okay. I had a friend that was a Cajun. Wow. This guy would punch you in the back, punch you in the nose, and then he would put his arm around you and go, "How you doing?" He just hit me, you idiot. It's like he was bipolar or something. And he'd flip from one to the other. Jared Loeffner had a history of bizarre behavior. He had been expelled from Pima Community College for classroom outbursts. He posted bizarre things on the internet. On 8 January 2011, he entered a political rally and killed 6 people and wounded 13, including a U.S. congressman, who he shot in the head, but he didn't kill her. Does anybody know why it didn't kill her? He shot her at an angle, and what happened was it entered back here, and it came out this side, and it didn't damage very much of her brain. That's why it didn't kill her. There he is. Does he look sane to you? Psychiatrist testified in a competency hearing that Loeffner suffered from random and disorganized thoughts, experienced delusions, answered questions in an irrelevant fashion. They diagnosed Loeffner as having schizophrenia. Loeffner has been remanded to Federal Medical Center in Springfield, Missouri. That's the place to go if you've got a mental problem and you're a criminal. Most evaluations over the last 2 decades have been conducted in the community on an outpatient basis. Physicians, psychiatrists, psychologists, and social workers are authorized by most states to conduct competence examinations, but psychologists are responsible for most of the reports. So a social worker can do it, but it has to be co-signed by a psychiatrist or a psychologist. Having mental illness or intellectual deficits does not guarantee that a defendant will be found incompetent to stand trial. They can still potentially stand trial. If someone has an IQ that's below 70, can they stand trial? It all depends on the state. Some states will allow them to stand trial and some states won't. There was a case a couple of years ago where an individual with a low IQ was watching wrestling with his brother. They started to reenact all of the... They started reenacting what was going on television, and he body slammed his brother. Well, he was big. He weighed like 300 pounds. And his brother was small. He only weighed about 110 or 115 pounds. Well, he killed him. He crushed him when he body slammed him. So the question was, could they try him as an adult for manslaughter? They were going to try him for manslaughter. It wasn't the death penalty. This was in South Carolina. And of course, in the state of South Carolina, somebody with a lower IQ can be convicted. And in this case, that's exactly what happened. So they convicted the individual of, they were both in the foster care system. They were both in the foster care system. And that's what happened. So they were trying to decide what to do with this kid. Several instruments are available to assess capacities relevant to competence to stand trial. Interdisciplinary fitness interview are semi-structured interviews that evaluate a defendant's abilities in 5 specific legal areas and assesses 11 categories of psychopathological symptoms. The IFIR We have a revision now. Ah, there we go. The fitness interview test is a structured interview for assessing a person's competence to stand trial. It includes 16 items in 3 broad domains: factual knowledge of criminal procedure, appreciation of personal involvement in and importance of proceedings, and ability to participate in defense. I have no idea why I put that picture up there. I have no idea. Sometimes I just throw pictures in, and I have no idea why I did it. Mcarthur's structured assessment of the competence of criminal defendants consists of a vignette about which the defendant is asked 82 questions that tap foundational and decisional abilities. It takes 2 hours to complete. Now, what's the probability if we've got somebody that is questionable as to whether they can stand trial or not, what's the probability you're going to be able to talk to them for 2 hours and ask them 82 questions? If they can answer all the questions, I guess we're okay. If they can't answer all the questions, then they're like me. I don't know if I could answer 82 questions after being given a vignette. Mcarthur's competence assessment tool, criminal adjudication, is a shorter version of the MAC-SAC CD. It too begins with a hypothetical vignette about a crime. Items assess the defendant's understanding of the legal system and adjudicative process and his or her reasoning abilities in legal situations. Other items are specific to the defendant's own legal situation. As exciting as this is, wait a minute, we're not done, I have more. The evaluation of competence to stand trial is a semi-structured interview that was developed using the Dusky criteria. Remember, Dusky was the one, was the first individual that they questioned as to whether he could stand trial or not in 1960. It assesses factual and rational understanding of the proceedings in consultation with counsel. It focuses on information that is specific to the case of the individual being evaluated. It addresses the question of whether the evaluee is trying to exaggerate or fake deficits that might make the person appear incompetent to stand trial. The famous ECST-R, revised, of course. The competence assessment of standing trial for defendants with intellectual disability, the CAST-MR, developed by Everington and Lucasen in 1992, was developed specifically for assessing defendants with mild to moderate intellectual disability. Okay. There was a reason why I put this lady's picture up here. And the reason is because she was one of the first people not to stand trial because of what was going on. There you go. My Little Pony.
Care Bear.
Care Bear. So everybody recognized it but me. Okay. Care Bear. Estimates of lingering, faking, or grossly exaggerating mental illness in competence evaluations are close to 18%. So faking is easy. So do you have a head thing that goes?
Yeah.
Oh, there you go. I can see it now. Very poor performance should make evaluators suspicious that a defendant might be exaggerating deficiencies. The Miller Forensics Assessment of Symptoms Test is the MFAST. Is a 25-item structured interview that can identify individuals who are attempting to feign mental disorders. Isn't that a great test to take? One that shows whether you're feigning mental disorders. Following assessment, evaluators usually give a written report to the judge that summarizes the evidence on competence to stand trial, as well as the likelihood that appropriate treatment will sufficiently improve competence-relevant deficits. This is really kind of interesting. You saw all of the tests that we can potentially give these individuals in order to determine if they are competent to stand trial. There's tons of different tests. So the question is, why is there always such an argument as to whether this individual is competent to stand trial or not? I know, it's very confusing. All we need to do is give them a test, and they either pass or they don't. Well, that's not completely true. It doesn't really work that way. what you can score somewhere close to the bottom, and you can still stand trial. I know. And one guy will interpret it one way, and another guy will interpret it the other way. And we always have two sides to every issue. We have the defendant and we have the prosecutor. And each side will have their own psychologist, and each psychologist will interpret the results differently. Sometimes there's a formal competence hearing where the evaluating experts testify and are questioned by attorneys from both sides. In formal competence hearings, who bears the burden of proof? A state can require a criminal defendant to prove that he or she is competent. The first time we saw this was in Medina versus California. Most states establish the criterion to be a preponderance of the evidence, meaning that the defendant had to show that it was more likely than not that he or she was incompetent. We see this a lot in murder trials, where an individual is very upset by something that has happened in the family, and so they murder, they get very emotional and they murder somebody. Are they competent to stand trial? Were they momentarily insane when they killed somebody? The individual that shot and killed 11 people in elders. I mean, some of those people were, I mean, they were my age. That's how old they were. 3 of them were older than me. My God. Nobody was younger than 64 years old. He just went in there and shot old people, which seems kind of silly or different and strange. So is murder a sane or is it an insane act?
It's on the individual
The individual
that's doing it.
is
Well, it's an insane act, I guess.
is murder always an insane act? I mean, we train soldiers to kill,
So
right?
that's what I mean, it depends on the person at the time.
So should only soldiers go to jail? Wait a minute, that doesn't make sense. Or if you're not a soldier and you weren't trained to kill, is it still sane or insane?
It'll probably be sane. Insane would probably be more of like a passion kind of kill because, I don't know, that is tough.
I know.
How would you argue that?
I know. So was it insane to kill 11 people? Was it insane to try to break into a black church and then go over to Kroger's and shoot the 2 oldest black people that you could find? One guy was 69, the other lady was 67.
Both of them were.
Was that sane or was that insane? He tried to break into the church. Here we had another guy that tried to break into a church. They had just had a service and they locked the door so that they could clean the church. That's the reason the church was locked. He couldn't get in, so he went over to the Kroger's and he started blasting away at the 2 black people that he saw. Because he didn't like African Americans. Is that sane or is that insane? Is it sane to hate? Wow. This must be a psychology class. Is that a sane act or is it an insane act? He said, pulling up his cummerbund. I know, it keeps slipping down.
My friend asked me, just randomly asked me the other day, she's like, why are people so mean to each other? Just like, why do they have to be like this to each other? And just instantly, it was at an odd time, so I just kind of woke up. But instantly what I said was just like, well, it's kind of just like human nature, you know, it's survival of the fittest, like, people just want to one-up each other. But that wouldn't I don't think that would go towards, like,
Sanity or insanity?
Yeah.
Okay.
But that was just something similar that I had over the weekend.
So you had the same conversation. Was she upset about
No, it was just like a random, just like tell me what you're thinking type of thing.
Oh.
So we usually have those type of moments. So.
So it didn't have anything to do with the 11 people who were shot?
No. Well, that was just like my answer. Like,
Or the 2 people who shot at Kroger, or the guy that sent all those bombs in the mail. Was that a sane or an insane act?
I don't know, it's hard to tell because of a lot of the influences that we have from our leaders, not just the present one, but even the ones before.
Sure.
What is allowed, what is tolerable, I guess. And in that way, I guess it wouldn't be insane, but it wouldn't be sane either. So, I don't know. That's
Okay.
a tough one. I don't know.
This is a tough one.
What do you guys think? Travis, help.
I think the question is every human being have that insane act, an insane mentality?
So we're both sane and insane at the same time? Okay.
That's the question.
Okay.
So for example, if you had thoughts of maybe when you got stabbed by your ex-wife, like, oh, was it insane?
I had that
thought.
I had that thought.
So does every human being have that thought or mentality? Or
I actually
some people act on it.
pinned her up against the wall by her neck after she stabbed me. I didn't hurt her. I wasn't really touching her. It's not like I was strangling her. She had just tiny little.
Dude, she had a knife in you.
I know, wow. The knife had fallen out by that time.
You pulled it out. I don't know, that's crazy. It's kind of like Dr. Jekyll and Mr. Hyde. I actually recently watched the first version of that in black and white the other night. And just watching him pass between the two and how he was unhappy with being, you know, Dr. Jekyll. And so he would go back to being Mr. Hyde, or Mr. Hyde would initially just start overtaking him more and more
Right.
because of the natural instinct he has to be aggressive or anger. I don't know, it was strange watching that because it kind of displayed like how humans act too.
That was written by Robert Louis Stevenson, and he wrote it in like 10 days after he started taking cocaine.
Mm-hmm.
Yeah, he was using.
Yeah, that's
cocaine.
what I was gonna say. That feeling, it's kind of like a drug to them as well because unlike the drug, you know, the feeling still didn't wake up the same kind of neurons and dopamine and serotonin in the brain to respond.
So there is a question. I mean, there is a question that we have to ask, and that has to do with alcohol. So when some people drink because they don't like the person they were when they weren't drinking. They like the person that they were after they were drinking. They were more outgoing. People talk to them more. So is that an insane act? If you're drinking to change your personality, is that insane? Sounds insane to me, but But then again, I'm a teetotaler, so I'm no fun at all, and I'm no fun at all. So I don't feel like I have to have a good time, or I don't find that to be a good time.
I think the second one was a better answer. It's just what you find is a good time to you.
Right, right. But it's not to me.
Mm-hmm.
Okay.
But it can be to other people.
Well, sure.
I
And
guess
maybe to have a
that's
good time. Does anybody have to get drunk to have a good time? I'm just curious.
I do cry.
You cry too? I cry. I drink. I get unhappy.
I don't know, I think if I drink, I'm better off if I'm by myself. or fishing. just outdoors, because indoors, confined area, I get too big for the room.
Wow.
Yeah.
That's.
I usually just take my walks and just,
I would. If I were you, I would never.
that's why I don't.
There you go. Okay. Just a thought. Okay. Well, this is kind of an interesting concept. About 70% of the defendants referred for evaluation are ultimately found competent to stand trial. If they are incompetent to stand trial, they can't understand. So that only 30% fit the criteria, that they can't understand what's going on. When very rigorous examinations are conducted, the rate approaches 90% are found competent to stand trial. However, there you go, okay.
This girl's got pasta for days.
I started feeling when I was walking up here.
You're not supposed to. Oh. Okay, that's right. What sort of person is most often judged to be incompetent? Nicholson and Kugler in 1991 found that the typical defendant to have a history of psychosis for which previous treatment has been received, exhibits symptoms of current serious mental disorder, be single, unemployed, and poorly educated. Really? They're going to look at this stuff to determine if you're incompetent to stand trial? If somebody is willing to live with you, then you're competent to stand trial. If one person can put up with you,
Then maybe the rest of us can.
then maybe you're competent enough to stand trial. But when we look at we look at the bomber.
Yeah.
We have this individual that lived in his truck, his van. He lived in his van all by himself once again. So we've got somebody that's single. I guess he was at a strip club and he was the DJ at the strip club, so he's not unemployed. Is he poorly educated? Well, I'm not sure whether he's poorly educated or not. It hurts, doesn't it? Yeah. Perform poorly on specific competence assessment instruments, of course. But they have to have a history of mental illness, as confusing as all that is. For those found competent to stand trial, the legal process resumes. For those found incompetent to stand trial, the charges are occasionally dropped, especially for less serious crimes, sometimes in exchange for requiring the defendant to receive treatment. And of course, Loeffner was found incompetent. And so he's in a mental hospital, probably for the rest of his life. Or would you let him go if he starts showing improvement? He killed 6, wounded 13. Gonna let him go? He shot a U.S. congressman.
That changes everything. It actually does.
Oh, so we're gonna let him go because he shot a congressman?
No, it's not.
It's a logical thing to do.
Because he did.
I'm impressed that you put on that makeup so well. I mean, mine, I couldn't get it on straight. So mine's all flaking and yeah. Look like I've got problems. In other cases, the defendant is hospitalized to be treated for restoration of competence, which, if successful, will result in the defendant proceeding with the disposition of charges. In other words, they can find him incompetent to stand trial now, but they can try him later on if eventually he is found competent to stand trial. Outpatient treatment is used less often. Of course, this individual will go into a mental hospital and will be treated until he is competent to stand trial. Prior to the 1970s, defendants found incompetent were often confined to mental hospitals for excessive periods of time, and that's what the mental hospitals really looked like back in before the 1970s. This practice changed with Jackson versus Indiana in 1972, which ruled that defendants incompetent to stand trial could not be held more than a reasonable period of time necessary to determine whether there is a substantial probability that they will attain that capacity in the foreseeable future. In other words, in 1972, they decided that you couldn't keep them indefinitely in a mental hospital if they weren't charged with something, if they weren't found guilty, if they had never went to trial. You couldn't hold them indefinitely. And that sounds like the state of Indiana, a very conservative state, where crazy, crazy, crazy things tend to happen. How successful are efforts to restore defendants' competence? Most defendants have their adjudicative competence restored, usually with about 6 months of treatment. The most important intervention for most defendants is the administration of appropriate psychotropic medication. Now here's the bizarre aspect of this whole situation. So let's say that you kill somebody and you're schizophrenic, and you've been treated for schizophrenia before. So you go to the you go to the judge, you go to the defending attorney, and the defending attorney says you're schizophrenic, you're nutty as a fruitcake. So we're going to plead incompetent, not guilty by reason of insanity. And of course, you go to the judge decides he can't stand trial. He's too crazy. So why am I crazy? I'm schizophrenic. Why am I nuts? What's wrong with me? Well, I stopped taking my medication. So now all I have to do in order to go to trial is to take my medication. And now I will be competent to stand trial. So do I take my medication or don't I? If I take my medication, then I'll stand trial. I'll be convicted of murder, and potentially I'll be executed. So do I take my medication? Or is it more insane for me to take my medication, stand trial, and then be executed? So what should I do? Or what will I do? Well, I stopped taking my medication for a reason. Usually it's paranoia. This is, yeah, okay, so this is a real strange situation. So if I take my medication, then I'll stand trial and potentially I'll have to go to jail forever. Otherwise, I get to go to a mental hospital, which is not nearly as bad as the prison. Potentially, I won't be molested by 500-pound linemen that got arrested for something. Anyway. Charles Sell had a history of mental illness that waxed and waned with the stress in his life. During an economic downturn, Sell was accused of filing fraudulent insurance claims. Found competent to stand trial, he was released on bail, and his behavior became more and more erratic. He began filing more fraudulent claims and was accused of attempted murder. Sell's bail was revoked and his mental state began to severely deteriorate. The judge ordered Sell to go into onto psychotropics to return him to competence. Sell refused and the case went to appeal. Sell was eventually put in a mental institution indefinitely. Okay, so that's the situation. So if I have a mental illness and I go on my medication, now I'm competent to stand trial. But if I don't go on my medication, and I can refuse my medication, of course, then potentially I will get to go into a mental hospital instead of jail. And of course, the 500-pound line. In my case, it would be a 200-pound line. What happens when treatment is not successful in restoring competence? Theoretically, the Jackson ruling bars the indefinite confinement of an individual adjudicated incompetent to stand trial. So they can't keep you in jail forever. Many states permit the defendant to be hospitalized for a period up to the maximum sentence that he or she could have received if convicted of the charges. So potentially I'll go to jail I'll go into a mental hospital for as long as I would have had I been convicted. But that's better than going to jail. Or is it? Which is better, a mental hospital or jail? You want to go to jail rather than a mental hospital? Okay. You did a really good job with your makeup. I'm so glad. You did a really good job. I'm really bad at it. I'm trying to spray my hair and I can't hit all the spots. And it's leaking down my face. That was horrible. That spray that you spray in your hair to make it a different color, it leaks. It drips down your face.
I have like 5 layers.
You have 5 layers on? How long did it take you to do that?
Like 2 hours.
Oh my goodness gracious.
This morning I started with like the crayon makeup.
Okay.
And it wasn't working. So I had my archery friends help me. I put on a couple layers.
That's so much better than mine. I'm so impressed. But I don't think I'd take 2 hours. I would have had to have gotten up at 4 o'clock in the morning. Which I did. Got up at 6 or something. What happens when treatment is not successful? Restoring competence. Defendants whose competence cannot be restored are typically committed. Have I already talked about that? Typically committed to a hospital through involuntary civil commitment proceedings. The state must show that the person is mentally ill and either imminently dangerous to himself or herself or to others, or so gravely disabled as to be unable to care for himself or herself. One of the things that we have to recognize is that a lot of people there's a lot of paranoia out there, okay? There's a lot more paranoia now than there seems to have been in the past. So a lot of mental illnesses are anxieties, depression. They are accompanied by paranoia, which is not a mental illness. It's just a fear of other individuals. But there's a lot of it out there, and there seems to be a lot more of it now than there has been in the past. So I'm wondering if in the future we're not going to see more and more paranoia, and of course the paranoia is going to precipitate the incarceration of some of these individuals. The 3 individuals over the weekend, I mean, why in the world did they do what they did? Shot 11 people in a synagogue. Why? He wanted all Jews to die. Why in the world? What's so dangerous about a 97-year-old woman? Why would you shoot that person? There's got to be a reason for it. He said that Jewish people were going to, they were bringing people into the United States to replace white people. That's what he was afraid of. That's why he was scared. Another form of paranoia. The guy that shot black people, what's wrong with black people? Why are they so scary? I mean, we look scarier than, obviously. We've got makeup on. Well, your makeup's not that scary. So what's wrong with black people that you'd be so paranoid that you'd want to shoot them wherever you found them? You'd want to go into a church and shoot them. Remember the kid that shot up the church in South Carolina? He killed 11 people. They had a Bible study, and he participated in the Bible study. And afterwards, he pulled a gun and shot everybody that was in the Bible study. Shot and killed them. He knew they weren't dangerous. He just talked about the Bible with them for 45 minutes. So what's so dangerous about it? It's this odd paranoia that we have. Why in the world would somebody send a bomb to Bill Clinton? Is Bill Clinton trying to kill people? We know CNN is trying to kill people. Right? So this is paranoia. This is this really strange paranoia going on. And it's going to get worse, as far as I can see, because it has gotten worse. And we don't have somebody that's trying to tell us, hey, come on, let's not do this. And did anybody notice what happened yesterday when the president went to Pittsburgh? The president went to Pittsburgh and nobody showed up. Normally it's like the whole bunches of people will go and just to see him get off the airplane. Nobody showed up at the airport except a soldier. There was a military guy there. And that military guy took him to the synagogue. But there was, I mean, it was different. So we'll see what happens. I keep saying that. Anyway.
Would the medications a person be taking also contribute to that paranoia or even substance abuse?
That's a possibility. The individual that had all the bombs, the one that sent all the bombs, potentially he was on steroids. Of course, we potentially may find that out. He's in jail right now, so we have him. We can draw his blood and find out if he's been on steroids. So it could have been the steroids that caused him to be so paranoid. But looking at his van, I mean, you saw all the pictures on his van. A lot of them had to do with targeting people. He had a picture of Hillary Clinton inside a gun sight. So I don't know. I don't know. I guess we'll find out. Or maybe we won't. What happened? We never found out about the guy in Las Vegas, and we're still so confused about that guy. That could happen again. But why did it happen to begin with? What was his motive? What was his modus operandi? Why did he do that? Why did he have so much ammunition? I mean, he had to accumulate all those weapons with those bump stocks. Not the easiest thing in the world to do, with all that ammunition. What happens if an incompetent defendant does not meet the criteria for involuntary hospitalization? Despite the ruling in the Jackson case, some states can find incompetent defendants for indefinite periods. Does this jeopardize defendants' due process rights? That's the question, and the answer is obviously yes, it does. For most defendants found incompetent to stand trial, psychoactive medication has been the treatment of choice. Can incompetent defendants refuse this treatment? Can you refuse treatment? You have the right to refuse treatment. Can they force you to be treated? In some cases they can, but it's relatively rare. We have seen cases where not the individual refused treatment, but they were too young to decide whether they could have treatment. The parents were of a religious order that didn't allow treatment, and the state has seized those children from those parents and treated the child to save the child's life. We've seen cases like that. So the question is, can they refuse treatment? And the answer is yes. However, can we force them to be treated? And the answer is, in some cases, we can, depending on the state. The government may forcibly administer psychotropic medication if the treatment is medically appropriate, if it's substantially unlikely to have side effects that may undermine the trial's fairness, necessary to significantly further important government trial-related interests, as in the case of Sell versus the United States. So we can force them to take their medication. Competence to waive Miranda Rights. The waiver of Miranda Rights is required in order for defendants in police custody to make a confession, and the waiver of these rights must be done in a knowing, intelligent, and voluntary fashion. And of course, we've seen this on television. The guy comes in and they read them the Miranda Rights, and then they just start questioning him. Is it possible that he can waive his Miranda Rights? The Miranda Rights basically have to do with having a lawyer present. That's really the big deal about the Miranda Rights. I almost touched my face. I know. I want to scratch my face. But you can waive those rights, and that's normally what happens. The assumption is that if you waive the rights, then you're not guilty, or you're less likely to be considered guilty. If you are guilty, you're more likely to ask for a lawyer. At least that's what the police will tell you. This assessment is challenging because typically the waiver and confession have occurred months before the professional's evaluation. And of course, if you are incompetent to stand trial, then potentially you were given your Miranda rights when you were incompetent to even make that decision. The Supreme Court has held that defendants have a constitutional right to waive counsel and represent themselves at trial, providing that this decision is made competently. And that was determined in 1975 by Ferretta. And I found a picture of Ferretta, so that's kind of exciting. The judge must be convinced that the waiver of counsel is both voluntary and intelligent. And this is the big deal. It's the lawyer. Even the case with the bomber. We know that we have all this evidence that says that he was the guy that sent all the bombs out. The government has gone into his van. They found all of this equipment for making pipe bombs. It's the same equipment that was sent out to the 15 people thus far that we found. So we have all this evidence against him. However, his lawyer is pleading not guilty. And his lawyer is telling him not to say anything. Now this is the reason why of course, Miranda rights are so important. Because the lawyer will tell you to shut up and not say anything. Not testify. If you testify, then you're SOL. If you allow yourself to testify, then you'll probably go to jail. And whose fault is that? It's your fault, of course. So you have to waive the rights both voluntarily and intelligently. And the police will try to convince you that if you don't waive your rights, then obviously you're guilty. And if you do waive your rights, obviously you're innocent. So that's what they try to convince you of. Competence to refuse the insanity defense. In some cases, the courts have suggested that only mentally responsible persons should be punished, thus requiring the imposition of an insanity plea even on unwilling defendants. And this happened in 1965 with an individual by the name of Whalen. This is certainly not Whalen in 1965. Not that much color film back then. But Frendak versus the United States in 1979 ruled that if the defendant understands the alternative pleas and their consequences, the defendant should be permitted to reject an insanity plea. And of course, this is something that we see from time to time. An individual that we know is nuts. We know this individual could get off with an insanity plea. But most people that are insane, especially the ones that are psychotic, don't recognize their own insanity. They don't recognize the fact that they're not competent. They think that what they think is correct. Anything that they think is correct. Well, we all have that feeling that whatever my idea is the right one. But if you are insane, if you are schizophrenic, if you're suffering from bipolar disorder and you're in your manic phase, a lot of times you think that whatever you think is correct. The people that are paranoid. Remember, there was an individual that thought that Bill and Hillary Clinton were running a child trafficking operation out of a pizza parlor in Washington, D.C. He thought that. So he took a gun there to free all the kids. It was a pizza parlor. There were kids inside, but they were eating pizza. And they weren't there because they were being trafficked. They were teenagers. They were eating pizza. And of course, he caused all kinds of a stir. And now the question has come up. He's going to trial. So the question has come up, is he sane or is he insane? He read a blog on the internet, and the blog on the internet said that that Bill and Hillary were running a child trafficking out of that pizza parlor. So is he sane or insane?
He'll be insane because he had a delusion.
It wasn't his delusion, it was somebody else's delusion. And he just accepted somebody else's delusion.
Accepted someone else's crazy.
Yeah, well, I mean, we all may be accepting somebody else's crazy.
Yeah.
I mean, we're going to vote. Yeah, here we go. Yeah, you're listening to me. We're all going to vote on Tuesday, aren't we? Except the baby, of course. The baby probably won't vote. Is she old enough to vote now?
He's only 3.
Oh, I'm sorry. Does that mean he can't vote?
Yeah.
You could help him vote. Okay, so we're all going to vote on Tuesday, and we're going to vote for whoever we vote for. Is it possible that we're accepting somebody else's delusion of who that person is? I mean, you guys get to decide between McSally and Cinema, right? Okay. So you're going to have to vote for Senator. You have to go with McSally or Cinema. Well, maybe neither of them are any good. And I've just started watching all of these attack ads. But of course, I get to see television in New Mexico. But they're attack ads, and they're saying really horrible things about the 2 people running for governor in New Mexico. Pierce and Grisham is her name. Okay. Which one are any of those correct? Can you lie on television? Can you lie on the internet? Is everything on the internet true? What? Well, how do you know what's true and what's not true? And if I believe something that's not true, am I accepting somebody else's delusion? That was what you said. Okay. Finally, I got it back around to the delusion. Okay. Oh no. I'm accepting somebody else's delusion.
A good example of mass delusion, Orson Welles, how he did
there you go.
the radio announcement.
The War of the Worlds.
People thought it was aliens.
It was real. And you know, the strange thing is that he was a very famous producer after that. And that's really the only good thing that he ever did, except for, what was that strange movie that he made? Yeah, he only did 2 good things in his life, but he made lots and lots of money from his reputation. Competence to be sentenced. In general, the standard for competence to be sentenced is that defendants can understand the punishment and the reasons why it has been imposed, and can meaningfully execute their right to address the court at sentencing. And of course, they have the right to address the court. And usually they will. And usually they say, I'm sorry. Or they'll say, I'm not guilty, and why are you doing this to me? Competence to be executed. The United States Supreme Court decided in the case of Ford versus Wainwright in 1986 that the 8th Amendment ban against cruel and unusual punishments prohibits the execution of defendants while they are incompetent. So that's one of the things that, if you are about to be executed, you'll try to prove that you're incompetent so that it will delay the execution. Researchers have found that participants who were age 15 and younger were significantly impaired in ways that compromised their abilities to function as competent defendants in a criminal adult proceeding. So if you're younger than 15 years of age, or 15 or younger, then you're not really competent to stand trial. Below average intelligence was also associated with deficits in these functional legal capacities. A large proportion of adolescents in juvenile justice system have below average intelligence. What an interesting idea. So these individuals are having difficulties in the criminal justice system. It is more likely that an adolescent with limited functional legal capacities would be adjudicated competent in juvenile court than if he or she were tried in adult criminal cases. And this, of course, is a kind of an interesting situation. Because in some states, individuals who commit crimes and they're underage will be tried as an adult. And of course, the problem is that a lot of times these individuals they're incompetent to stand trial because they are underage and their brains are not mature yet. So we know that the human brain doesn't mature until you're in your middle 20s. So if somebody gets arrested at, say, 21, 18 or 19, they're an adult, they've done something bad, they've done something wrong, or they murdered somebody. Should they be thrown in jail for the same amount of time as if somebody murdered somebody when they were 30? If they're competent enough to pull the trigger, are they competent enough to spend that much time in jail? Or should we look at that? Should we look at the maturity of the human brain as a criteria for how long somebody should be punished? I got one yes. 18-year-old, 30-year-old, does it make any difference? Yeah, same size. They can do the same damage. Shouldn't they get the same punishment? I got no. I got a. What do you think? Same punishment? Same punishment. Same punishment? Different punishment. This is like that lady asking that question. Remember the lady asking the question? I mean, just right off the top of her head, she asked you this crazy, crazy question.
I don't think I was.
Did some lady ask you a question? You just told me about it. He told the whole class about
Oh, you're talking about that? Okay.
Oh, that, yeah, okay.
No, that depends.
See, I'm doing the same thing. I'm asking you a stupid question. We already know it. I didn't notice you had purple. Oh, you're an older woman.
Their veins popping
Veins.
in.
Well, we won't ask the care bear. What do you think?
I think that age should be taken into consideration.
Age should be taken into consideration. Whatever she said,
It's
right?
just the same punishment.
Should age be taken into consideration? Hell no. No?
What are you
Not-
doing over there?
Same punishment.
Same punishment? What do you think? No? Should age be taken into consideration? Were you stupid when you were 18, or were you really, really so damn smart you're just as smart as you would be when you were in your 30s? Everybody knows that 18-year-olds are the smartest people in the world.
Yeah, that's what he loves.
And they don't realize how smart they are until they're Should it be taken in? So it should be taken in. Okay. They're going to spend longer in jail because, well, we won't go into that. Okay, I was just curious. The insanity defense requires one to gauge a defendant's mental state at the time of the offense. This can be very difficult to do. Of course, we were just talking about passion. So something passionate happened. What was that? There was a movie of something, it had, it was a prison movie. And the guy, in a fit of passion, he murders his wife and his wife's lover. In a fit of passion. So they put him in jail forever. Instead of executing him, they put him, give him a life sentence. Something redemption. Shawshank Redemption. Shawshank Redemption. That's the deal going with that character. Note that insanity is a legal concept, not a psychological one. Although mental health experts can offer diagnoses, this is less important than the specific symptoms and their impact on the functional legal demands associated with the insanity standard. And I just asked you guys whether murder was insane. We agreed that soldiers aren't insane when they murder or they kill somebody. So then we have to think about the guy going into the synagogue and shooting 11 old people. I mean old people. These are old people. Or the guy shooting the two African Americans. Or the guy standing on the 36th floor in Las Vegas and shooting at a crowd of people. He can't even see these people. He's just dropping rounds in and among these people. How sane or insane is that? How competent would we consider him? Is that a sane act? So now we're trying to determine why he did it. Because he's dead. He committed suicide. We don't know. We can't ask him. We can ask the three guys from this past weekend, the bomber, the guy that shot the black people, and the guy that shot the Jewish people. We can ask them, were they sane when they did what they did?
I think they all were. It's just the act wasn't insane. The act of it was insanity because it is against the social laws and rules which we all abide by.
Yeah, just whatever
But
they
there is.
But
there,
is it against their social laws?
no, it's not. Because they are influenced by different things. Everyone is influenced by something specific or different from one another. So you can't call that person crazy for believing in something they believe in, but you can call something that they do because of that reason. Not the person, but the act.
So in a court of law, do I determine their sanity or insanity by
Their actions.
well, not by their action. I was thinking by their background.
That's what I was going to ask.
Yeah.
Is their background? Because I don't know. It seems people that get into that part, where they get so far into what they're doing or believing or what they're influenced by, that it kind of gets, I guess, 40 in there for that bit, because
Sure.
their past has an influence on their actions of the present.
Well, we saw the bomber at Trump rallies holding up a CNN sucks sign, and with pictures of targeted political figures on it. Is that sane or is that insane?
That's sane because that is something that is their social idea of fitting into this,
Yeah, 'cause
their own form of social.
he was not the only. He was probably not the only one thinking that.
Certainly not.
So, it was just in that area that social concept trying to support it. But in general, like it's not.
So he's sane.
In that particular group, yeah.
Yeah, because of that group. Wow. Now the sad part, or the interesting part is that this is the group that supports the president. So he's certainly not going to call them
Anything less.
anything insane. Otherwise he can't vote and he won't be elected next time. Oh man, this is tough. This is really tough. Although mental health experts can offer diagnoses, okay, we already talked about that. Okay, so we've already tried to diagnose the situation. The legal standards that define criminal responsibility vary from state to state, but in all states, the defendant has the duty to present evidence that would disprove the presumption of criminal responsibility in this case, in their case. To be a criminal offense, an act must be illegal and accompanied by the necessary mens rea, or the guilty mind. And this is the tough part, this mens rea. We've got 3 defendants from this past weekend. And the question is, do they have a guilty mind? Or is this acceptable behavior within their own context? If you have ever seen somebody coming out of prison, a lot of times they will have teardrops coming out of one eye. I think, they have teardrops coming out of their eyes. What do those teardrops mean? There's a meaning behind the teardrops. They killed somebody. Now, in the prison context, that's acceptable behavior. Among that group, that is acceptable behavior. But when you look at somebody and you know that they've killed somebody, is that acceptable behavior? In the prison context, that's acceptable behavior. But do you see that as acceptable behavior? In the society that you live in, we all live in a different society, but in the society that you live in, is that okay? Is it all right to have killed somebody? Do you want your neighbor to have 3 teardrops? 2 on one side, 1 on the other. It means something. Yeah, the different eyes mean something, but it may mean something different for different places. I don't know. Do you want to live beside somebody with teardrops coming out of, tattooed teardrops coming out of their eyes? What do you think? When I was living in Mississippi, I had a student, and she would only date men who had been to Parkman. Parkman was the state prison for Mississippi. And it was a vicious place. And she only wanted to date these guys because they were tougher than everybody else. And sometimes they had teardrops coming out of their eyes. Well, tattooed teardrops coming off of their eyes. She found that exciting, that these individuals were murderers. She found it exciting that they had been to jail. She wouldn't date anybody that hadn't been to jail. Is that normal? Is that logical? Does that make any sense to you? You want neighbors with teardrops. You wouldn't have to worry about somebody stealing your stuff. My neighbor's got teardrops. You better be careful. That's probably the teardrop guy that's stealing your stuff. Okay, so the criminal mind is the guilty mind is one of the aspects that we have to think about. The McNaughton rule is an early attempt to define insanity. The McNaughton rule excuses criminal conduct of the defendant as a result of a disease of the mind. He did not know that he was doing what he was doing. For example, he believed he was shooting at an animal rather than at a human, or did not know that what he was doing was wrong. He believed that killing unarmed strangers was right. The McNaughton rule is really kind of interesting. McNaughton was an individual that had a mental illness. Obviously, he tried to kill Queen Victoria. He tried to shoot her. His gun misfired. Somebody grabbed his arm. His gun misfired. He didn't shoot the Queen. He didn't kill her. The Queen was pissed, as you can imagine, and she wanted him executed right away. She wanted him beheaded, which they weren't even doing in England at the time. She was mad. And he went to court, and they realized the guy was as nutty as a fruitcake. And he didn't realize not only that she was the Queen, but he didn't even realize she was human. He didn't see people as people. He saw people as robots or automatons or something. Anyway, so the judge decided not to execute him. And it went all the way back to the Queen. And she was mad. She was really pissed. And so all of the people that had to make decisions before it got to her said that, no, this guy's crazy. We can't kill him. He's too nuts. And when it got back to her, she said, no, I want him executed. And so it went back into the government again, and the government decided not to execute him. And eventually he wasn't executed. Okay. But that was a McNaughton case. Fascinating case, because the Queen was upset. She was really upset. Somebody had tried to kill her. The McNaughton rule, or a close variation to the McNaughton rule, is used in 29 states and the federal jurisdiction. So in a federal case, the McNaughton rule is intact, as in 29 different states. It has often been criticized on the basis that the cognitive focus, the knowing wrongfulness, is too limited and does not allow consideration of motivational and other influences affecting the control of behavior. Most states will not allow you to kill somebody in a fit of passion. Most states won't, but there are select states that will. So if you decide that you want to off somebody and they're messing around, you can if you can catch them in the act, then you can kill them. And you can claim that it was a passionate impulse, and you will be acquitted. There are select states that do that. One of them is South Carolina. Another one is Mississippi. So if you kill somebody in a fit of passion, then potentially you won't go to jail at all. So if you hate somebody so much and you decide to kill them, you can do that as long as you can prove that you really hate them that much. And actually, once upon a time, guess who got off for killing black people? White people. Yeah, exactly. Everybody does. You were going to say something. No?
About McNaughton?
Yeah.
Like, what if he had like the Alice in Wonderland syndrome that was never diagnosed or treated when he was a child, and it kind of...
And this is right after Alice in Wonderland was written, so...
Yeah. And they found out that...
That's a possibility, I guess.
That syndrome.
That's fascinating.
Huh.
I need to finish this page. Okay. It has often been criticized on the basis that the cognitive functions... Well, okay, we already talked about that. Okay, we need to stop right here. And thank you for dressing up those of us who did.